Good morning. Time for coffee. Ooh, and time to feed the kittens. Have a great morning, and here's our next video. This is disbarment and reinstatement of lawyers. In this video, we'll talk about grounds for disbarment, the procedure for disbarment, and how disbarred lawyers can be reinstated. Let's begin. What are the basic considerations? First, lawyers are bound by some of the strictest moral and professional standards. Because of this, lawyers are deemed to be exercising the noblest profession. But what happens when they fail to meet the standards of the profession? Lawyers are not saints. They are not infallible. They commit mistakes. But what do we do with the corrupt, inept, and incompetent? The remedy against these lawyers is disbarment. The lesser sanctions that can be imposed are suspension, fine, and reprimand. So who has the power to discipline lawyers? The Supreme Court has ultimate disciplinary power over attorneys, and this power is both inherent and constitutional. The Court of Appeals and the Regional Trial Court may also exercise the disciplinary power, but they can only impose suspension and lesser disciplinary sanctions. If the infraction merits disbarment, these courts can refer disbarment proceedings to the Supreme Court. So what is the purpose of disciplinary proceedings? A disciplinary proceeding is instituted to ascertain if a lawyer, in view of the imputed conduct, still possesses those qualifications which are conditions precedent for the continuous practice of law. The power to disbar or suspend is exercised on the preservative and not on the vindictive principle, with great caution and only for the most weighty reasons. So why are disciplinary cases against lawyers sui generis? Administrative cases against lawyers belong to a class of their own. They are distinct from and they proceed independently of civil and criminal cases. A judgment in a civil or criminal case will not justify or bar administrative cases against lawyers. Also, add to that is that disciplinary cases against lawyers do not prescribe. So what are the grounds for discipline? Let's look at Section 7, Rule 138 of the Rules of Court. First, deceit. Next, malpractice. Next, gross misconduct in office, grossly immoral conduct, conviction of a crime involving moral turpitude, willful disobedience of any lawful order of a superior court, corruptly or willfully appearing as an attorney for a party to a case without authority to do so, and any other violation of the oath of lawyers. And because of this last ground, the list of grounds is not exclusive. Other infractions may be considered. And speaking of other infractions, the Supreme Court has used the following as specific grounds for disbarment, and they are grouped accordingly. First, under the group of breach of duties to the court are obstructing justice and abuse of legal processes, misleading the court, forum shopping, filing false charges against judges, introducing false evidence, willfully disobeying court orders and disrespect to the court. Now, under breach of duties to the client, negligence in the performance of duties, employment of unlawful means, deceit or misrepresentation, conflict of interest in revealing client secrets, purchasing client's property in litigation, failure to account or misappropriating client's property, collecting unreasonable fees, and acting without authority. Under the breach of duties to the bar, defaming fellow lawyers, communicating with adverse party, encroaching upon business of another, soliciting business, advertising, cooperating in illegal practice of law, non-payment of IBP membership dues, and misconduct as a notary public. So what is the procedure for disbarment? First, file a complaint with the Supreme Court through the Office of the Bar Confidant, or you can also file a complaint with the Integrated Bar of the Philippines. The complaint may be directly considered by the Supreme Court or referred to an IBP investigator or hearing officer. If the complaint is meritorious, the respondent lawyer will be directed to file his verified answer. Otherwise, the complaint may be summarily dismissed. A hearing may be conducted to give the respondent lawyer full opportunity to be heard and to present witnesses on his behalf. After the termination of the investigation, the IBP investigator or hearing officer will submit a report to the IBP Board of Governors. The IBP Board of Governors will review the case and render a decision and submit a recommendation to the Supreme Court. Both the complainant or the respondent, as the case may be, may move for reconsideration of the decision of the IBP. The Supreme Court will then act on the recommendation of the IBP, either to disbar, suspend, or fine the respondent lawyer, or to dismiss the case if warranted. The extent of disciplinary sanctions which the court may impose against an erring lawyer may depend upon the attendance of mitigating and aggravating circumstances. So instead of disbarment, a lawyer may simply be suspended, or instead of suspension, the lawyer may just be reprimanded. So what are these mitigating circumstances? First, good faith on the part of the erring lawyer. Next, want of intention to commit a wrong. Next, lack of material damage to the complaining witness. Desistance of the complainant. Youth and inexperience. Error in judgment. Counsel's first offense. And the lawyer's accepting his mistake and expressing regrets and apologies. Notes: desistance or withdrawal of the disbarment case does not exonerate the respondent lawyer. The case may proceed regardless of the lack of interest of the complainant. Also, because of this, a compromise is not recognized in disbarment proceedings. The absolute pardon from a criminal conviction by the President of the Philippines is not an obstacle to the disciplinary action against the lawyer who was previously convicted. A disciplinary proceeding against an attorney is confidential in nature until its final determination. And lastly, an attorney enjoys the legal presumption that he is innocent of the charges until the contrary is proved. The burden of proof rests upon the complainant to overcome the presumption. Now let's talk about reinstatement. Assume that a lawyer has been disbarred, and if he desires to go back to the practice of law, here are the procedure. But first, the Supreme Court has the exclusive authority to reinstate a disbarred or indefinitely suspended lawyer. Neither the IBP, neither the President of the Philippines can reinstate a disbarred lawyer to the practice of law. Now, the disbarred lawyer should file a petition for reinstatement, and this petition must establish to the court that the lawyer concerned possesses the good moral character requisite of admission to the bar and to the practice of law. The court may consider the following. First, the lawyer's character and standing prior to the disbarment, the nature and character of the misconduct for which he was disbarred, the time that has elapsed between the disbarment and the application for reinstatement, and the circumstances that he has been sufficiently punished and disciplined. And because the decision to reinstate is discretionary on the part of the Supreme Court, any other circumstances may be considered by the court, either favorably or disfavorably to the lawyer. I hope you learned something valuable today. If you have any questions, comments, and suggestions, let me know in the comments section below. If you like this video, please give it a thumbs up and please subscribe if you haven't yet. As always, thank you and see you in the next video.